Good morning. This is a special session of our series simply because of the most recent developments regarding the public charge inadmissibility guidelines that was set by the present administration. Now, this is important because this applies to all non-immigrant and immigrant visa processing abroad, entry into the U.S. of immigrant, meaning green card holders, as well as non-immigrant visa holders into the country, as well as the change of status, extension of status, and adjustment of status here in the United States. Now, this has reference also to the previous episode wherein people might need to do any or one of those. Now, what is a public charge ground for inadmissibility or denial of an application, or even disqualification in layman's terms? What that means is that people who have received public-based benefits from the government could be disqualified, or their applications could be denied, or their application for entry into the US could be prevented simply because they fall under any of the categories defined by the guidelines. Now, you have to understand that previously, cash-based public benefit does not preclude you from availing of any immigration benefit in the US. But in October 15 last year, the present administration implemented a guideline or guidance wherein the disqualification or the ground for inadmissibility has been extended across the board. So there's no more distinction between cash-based or non-financial benefit from the public government, from public assistance, with some exceptions. Now, let me start by who are covered by these rules. Number one, people abroad who are applying for a tourist visa or other non-immigrant visas. People abroad who are applying for green card or beneficiaries of approved petitions. That's number one. Number two, admission into the country of non-immigrant visa holders like HLJ and even tourist visas, or specific instances of green card holders coming back into the country. That's number two. Number three, people who are applying for their adjustment of status in the United States, meaning people who are applying for their green card here in the country. Who are not included: A, US citizens; B, members of the armed forces and members of their respective households; C, people who are receiving benefits on behalf of certain people under a special power of attorney or as legal guardians. Now, what are the benefits that have been enumerated? Medicaid, SNAPs, welfare, food stamps, Section 8 housing, and other subsidies by the federal government. What are the exceptions? Exceptions are, number one, emergency cases or need. Number two, school-based benefits, benefits under the Educational Disabilities Act, and also minor children under 21. They are not precluded from receiving these benefits, and pregnant women 60 days from the time of birth. Now, what's the duration? The duration is 12 months within a 36-month period, such that each benefit received is considered as 1 month. So it could conceivably happen wherein within a space of 1 month, you have received the benefits enumerated therein 12 times, and therefore you could be excluded if you have received more than 12 months within a 36-month period, and you have to be aware of this. Now, I have to tell you that this is not legal advice. The purpose of this flash episode, so to speak, is to make you aware of what's going on in the country. Now, what is worrisome is that these rules could actually be applied to green card holders. Before I go there, let me enumerate first the factors to be considered: the age, assets, family support in the country, education, prospects here in the country. So those are the factors to be considered. Now, what's the standard? Standard is so vague, such that more likely than not, one could be a public charge if more likely than not he will receive these benefits at any time or in the future, considering the totality of circumstances, weighing the positive and negative factors. One of them I just mentioned. Now, in fact, I'll give you a specific example enumerated in the guideline. If you have a work permit and you have not worked, that's one factor that could be considered against you. One of those is that if you have a pre-existing medical condition that needs continuing medical attention, and you're not insured, and your prospect of getting an insurance is very limited, and your medical condition could affect your chances of getting employment here, or even your family may not have the resources to afford the medical needs that you may need presently or in the future, you could be considered as a public charge. Now, there is such a thing previously, affidavit of support, wherein the family could show that may have the resources to some extent to support you or to answer your needs. This has been increased even to 250% of the poverty guideline based on your existing household. There's a table for that. But even then, even if you meet the 250% requirement of the income indicated in the poverty guideline, this may not be alone enough to meet the needs or to overcome the conclusion that you are actually or possibly or potentially be a public charge in this country. Now, what is worrisome, as I said, is that green cards could be holders, could be covered by this rule, meaning someone who has been here and who traveled abroad 180 days at a time may come back into the country, and the officer at the airport, at the point of admission, conceivably may interview the applicant, the green card holder, the returning green card holder, and he or she may be found to have a pre-existing medical condition, no employment history, advanced age, may need continuing medical attention, no health insurance, no prospects of getting one, and the family could barely support him or her. Conceivably, legally, potentially, he or she could be considered as a public charge. The practical effect is that they could be denied admission or they could be referred to the court for the charge as a public charge. Now, I've seen this happen before, way back years ago, where people entering at the border, one of the charges against them, aside from entering without the necessary legal documents, is that they could potentially be a public charge. Used to before that, the main requirement is you have a family member here who could answer or could meet 125%. That was the threshold of the poverty guideline. But nowadays, even meeting 250% by way of an affidavit of support would not be even enough for that purpose. Now, on top of that, you have to understand that there's a corresponding memorandum issued July 15 last month that defined discretion, because discretion as applied to this guideline is very much present and dominant. If you analyze it, whether or not, or more likely than not, you could or you may need to receive such public benefits, and you could potentially be a public charge at any time or in the future, based on the totality of circumstances, weighing the positive and negative factors with all the mumbo jumbo. At the end of the day, it's a matter of discretion, because it's really difficult to pin that down what those all means. Now, discretion is such a wide concept that USIS issued a guideline defining it in such a vague manner that at the end of the day, discretion really becomes very, very subjective. So if I were to put it mildly, it's like a rubber band that could be stretched to cover as many cases as possible, or that could be double wrapped as well around your finger, so as to fit a very specific, esoteric, rare cases, and to drag it into the dragnet, if you will. Now, why is this important now? in addition to this, there's this possible confusion as to when and where this particular guideline could be implemented. Let me give you a brief history of this guideline. October 15 last year, 2019, the public charge inadmissibility ground was supposed to be implemented. There was a litigation that went all the way to the U.S. Supreme Court. There was an injunction from New York, and there's another case in Illinois that prevented the implementation of the rule. However, before the U.S. Supreme Court, the injunction was stayed, meaning as of February 24, 2020, the federal government could actually implement the guideline as to those applications filed on or after February 24. However, the U.S. Supreme Court, in not granting a stay, likewise permitted the parties to file any appropriate filing before the respective courts. So as of July 29, the Southern District of New York issued another injunction again against the implementation of the rule in the middle of the pandemic, obviously. However, when it was appealed or before the Second Circuit ruled that such injunction could only be applied to 3 states covered within its jurisdiction. That would be New York, Connecticut, and Vermont. So we now have a situation wherein this public charge requirement or disqualification or ground for denial or as a ground for inadmissibility is actually true only for the rest of the United States and the world, except for the states covered under the Second Circuit, and that would be again Connecticut, New York, and Vermont. So we also have a situation wherein filings have to be considered as to when, not just where, but also when. When was it filed? Was it filed February 24? Was it filed July 29? Or was it filed August 12? And where was it actually filed? I suppose there's a federal case pending also in Illinois, and that's a different jurisdiction as well. You have to understand that there are 13 different circuit courts in the United States. And conceivably, just like in previous legal issues before, like the CSPA, each jurisdiction may have a different rule. And all these cases at some point will be consolidated before the Supreme Court. But at the rate we're going, it will not be most likely not before the U.S. Supreme Court until summer of next year. So it's very important for you to know what's going on. Now, I'd like to stress that this is not a legal advice. You just have to know what's the latest development in this, because things that you do now could actually disqualify you, could actually be a ground for denying your extension or change of status if you're doing such at this time, or could even be a ground for your inadmissibility into the United States in terms of adjustment. So at the end of the day, you have to know, as I said, what's going on, number one. Number two, you have to know what kind of benefits are you receiving, all right? And you have to know where are you filing, when was it filed, and what are you gonna do with it moving forward. There are many nuances, intricacies involved in this, so I would strongly suggest you go and consult a lawyer. The way I would picture it is we're literally going through a landmine in a quicksand. We don't have much of a choice but to tread through it, knowing the pitfalls and the dangers that may lie before us. All right, so I guess that's it. Hopefully you got the message on this special episode of our series. Be aware of it and be mindful also, and please consult a lawyer moving forward, especially if you're receiving benefits for each and every member of the family. Having said that, I want to make sure that you may be receiving benefits for other eligible USC members of the family, but make sure that you're not listed as a beneficiary for one. So those are the nuances that you have to be aware of. So summer is about to end. Hopefully you've enjoyed yours and you'll continue to enjoy what's left of summer. Be safe, and for those who cannot stay home, continue to be safe. Be well. Thank you.